Thank you, Jim. It's a great pleasure and honor to be part of this program today and to be here yesterday. And I know there was a look of panic among the audience when you said that I had stepped down from Texas Water Journal. I just want you to know that's not true. I'm still there. So this is an august group right next to me here. And if you're going to put together a group to talk about surface water, I'm not sure you could do better than this. So let me go ahead and introduce them, starting with Doug Caroom, who's on the end here. Doug is a partner at Bickerstaff. He, prior to that, was the chief of the Environmental Protection Division for the AG's office. And he's been an adjunct professor of water law at the University of Texas School of Law, and he has a BA, an MA, and a JD from UT. And just about every major water litigation you've seen over the last 20 or 30 years, Doug has been involved with in some way. Toby Baker, who is right next to Doug, is the commissioner for, one of the commissioners for the Texas Commission on Environmental Quality. He was appointed in 2012 by Governor Perry. And prior to that, he had worked in the governor's office on budgets and as a liaison with all the major environmental agencies in the state. He's been, of course, a major figure in trying to figure out what we're going to do with restoration of Gulf of Mexico and the habitat associated with that. But probably, he might say, most importantly, he is a proud graduate of Texas A&M, where he was a member of the Corps, and you got your master's degree from this very school here, the Bush School. So, welcome. And then right here next to me is Kevin Ward, who is the general manager of the Trinity River Authority, which has a larger territory than any other river authority in the state, I think. That's what I saw. I didn't realize that. And he's been there for several years, but prior to that, he was the executive administrator of the Texas Water Development Board. And he is also a graduate of the University of Texas. So you can see that you've got, a top flight group here. And we have one joint presentation, which Doug has prepared for us with some input from us. And we're going to go through that, and I'm going to offer up some questions as we do, in the spirit of some of the questions we had yesterday, and keeping some of those in mind. I'm going to interject a little bit of that today. So why don't we go ahead and start then, and if I can do this correctly. There we go. Surface water. So Doug, take it away.
Okay. Thank you, Todd. Surface water. Well, our idea here is we're going to walk through kind of an introduction to Texas water law for those here who may not practice in the area or be involved in the area all the time. And each of the panel members are going to contribute and discuss as we go through, and we'll highlight some of the difficulties as we go through also. So first principle is the state owns the surface water in Texas. And virtually anything that's more like a low spot in a pasture where the water collects or where storm waters flow, that's going to be state water. Every ravine, every depression, all that is state water. Now, diffuse surface water is water on the surface of the land before it enters a ravine or a water course of some sort. And that is not state property. That's private property. So you have things like rainwater harvesting being possible without getting a permit from the state. But if you go much further than that, you're going to need a permit from the state. So you want to go ahead, Todd, or pass down the clicker as we go? Looking at the historic development of Texas water law, the prior appropriation doctrine, it grew up in the other western states out of the mining gold rush and other operations. It's essentially stake a claim, work it, and you turn it into your right. And that was done. That's the way the prior appropriation doctrine started in Texas. You would file a claim, record it with the county, and then develop the water resource according to what you've claimed. And once you did that, it was a perfected property right. And the priority of your right depended on the date of your claim, and with the oldest ones having the best rights. So that during a time of shortage, the senior water right can shut off the junior water rights, or can ask that they be shut off to be sure that he has water available. And the commission has had some experience with that. So other things about the prior appropriation doctrine, it really doesn't encourage conservation very much, because you can lose your right if you don't use it fully. So there are statutes on the books that allow the cancellation of water rights for non-use. A prior appropriation right is limited to a specific place for a specific purpose for a specific amount of water. And that means essentially that in order to market it, in order to change it or use it for something else, you've got to go to TCEQ and get an amendment, which takes, you know, a year if everything goes well, and quite a bit longer if they don't. So the prior appropriation doctrine, you know, is real efficient at developing the resource, giving incentives for people to invest and develop the resource. But it's not great in terms of marketing or changing the way the resource is being used.
I'd jump in on that. I think the perfect example of how the prior appropriation doctrine works is sort of what Doug talked about with the idea of a senior call. Back during the lean years, I'll call them, from 2010, 2011, when we were in arguably the worst single-year drought in the state's history. We had multiple senior calls by senior water right holders. Some of those senior water right holders were at the very end of the river. In particular, one named Dow Chemical. And so when a right holder like Dow, who has one of the oldest rights on the entire river, makes a senior call, what that means is, from TCEQ's perspective, is then we go back up the river, and every right that's junior or came after that right at the end of the river, we then have to go in and curtail what they have access to make sure that Dow can have access to their full permitted right. So the commission has not had to do this often. Somehow it lined up pretty closely to when I got onto the commission that we had to do this, and so we unfortunately now have precedent and quite a bit of practice at it. But it's but that's really where you could see how the prior appropriation doctrine really comes into play, is that in that setting.
Right, and then you have to look at it from a practical perspective as well. So when you're a river authority and you've got water rights that are down at the lower end of the basin, and in my case some that are fairly junior to most of the others in the basin, then you're looking at a system where probably at the very end of the river you have your most senior water rights. And so you have to protect the very end of the river. Well, that means it affects in the Trinity River going upward, everyone that we serve, including you can start with the big ones like Huntsville, and then you go all the way on up the river and you get to Dallas and Fort Worth and Tarrant Regional Water District. So everyone's affected when something like that would happen down further south from a very senior water right call. But at the same time, the system works. And there's a lot of extremely complex models that are run called WAMs. and there's a series of runs that are made with the WAMs. But the most important runs are those that
What does WAM stand for?
Water Availability Model. It does, although it does sound like something that someone would hit you with, and from time to time you exclamation point. And but the when you run these, when you're trying to apply for a change to a water right or a new water right, or in reuse permit, anything that involves diversion, you're going to run the model at least once to see if everyone drew all of their water, did full appropriation, regardless if they've ever done it before or not, or even if you think they're going to do it, you run it that way in order to see what that would do. And then you go in from there, backing into it. We get to some analyses that we do with modeling that get to the percentage of reliability and all that. And once it comes down to a bottom line of likely what you have, then the commission staff can make a recommendation on a permit. And it's a scary, process if you've never done it before, but it's a necessary process. And it does simulate what might happen in an extreme drought.
And it's incredibly technical. And when we were having to actually respond to those calls, we were able to get our kind of toot our own horn a little bit. We were able to get our response down to about 4 days on being able to really understand who had access to water after those senior calls were made and who had to be curtailed. And so it took, it was a very resource intensive activity to be able to get to that. But the problem is when somebody makes that senior call, they need the water now. Right. And so as quickly as possible, we have to figure out how that affects the entire basin. So, and I just want to reiterate what Kevin said. So if Dow makes a call at the end of the river, that affects the entire basin, all the way up. And so it's not a small thing when these things happen.
Yeah, it's when a priority call is made, it's very demanding on the agency's resources. It pretty much takes the whole water rights group and shuts it down and devotes its attention to dealing with this priority call. So it's, it's not the most efficient thing from an agency point of view on how to handle it. And the other aspect is the priority system doesn't take into account what the water is being used for. It's only the priority of the water. So that you can have, a farmer with a senior water right wanting to save his soybeans, taking water that otherwise would go to municipalities and industries that have a lot higher value than that field of soybeans. And that, we'll talk about that in a while. But that's another aspect of the priority system. If we're, talking about ways to change things, there are a couple of, Australia and some of the western states have worked at changing away from a pure priority system once they had it. But it's really difficult because these are vested property rights. They're constitutionally protected. So it's, it's a hard line to walk.
So that perfectly leads into my first question. Thank you. So this is Rethinking Water Policy. And as everyone's aware, or maybe not aware, there was a lawsuit a few years ago, the Aransas Project versus Shaw, where there was an attempt to essentially change prior appropriation in one basin, allocate water first to the environment and then everybody else. And that lawsuit was not successful. But there has also been kind of incremental change made to prior appropriation over time. And so I guess my question in light of the overall theme of the conference is, you hear criticism, people saying, hey, prior appropriation is maybe a thing of the past, and we should be moving to something else. What would that other thing be, and could it be done, and would that be a smart thing to do? I think a defense of prior appropriation is not a bad thing, but I'd just be curious when you hear people say prior appropriation, we need to move on to something else. What do you think about that? What's your reaction?
I think it would be a real legal challenge to get that done because they're vested property rights, and if you're going to modify them, there are going to be winners and losers. And the losers need to be compensated if you're going to do that, if you impact their rights significantly. So it's a real challenge, but you know, there are states and others that have tried to do it, and having a viable market system where the water could move to, its highest and best use from society's point of view, certainly would be worth trying.
Todd, this is where I think I think Doug's right that the legal hurdles are high. I think this is where the politics really comes in. As I look at the state population from 2000 to now, we've grown by millions. We heard Senator Williams talk about it, about how fast we're growing as a state. And people are coming here in droves. They're moving to the cities. If you look at what our population's done versus our water supply in the state, we haven't increased our water supply by any in that time frame. So we've done better on conservation. We have one new reservoir that will be coming online up in North Texas, but the reality is building reservoirs is extremely expensive and takes a lot of time and energy. And in some places, the government steps in and just takes it out from underneath you, like we had happen out in Northeast Texas. So what I see is, trying to do it now would be a real challenge. But I think at some point it becomes just the state gets too urban. The representation is going to come all from those urban areas, and the legislature at some point will act on that, in my opinion. I don't know when that tipping point is, but when we have to cut off a city so the farmer can get water on his soybeans, when that issue happens, and then the legislature, I think, will be compelled to act at that point. And when they do, I can't predict what they'll do, but I think that's what will change it.
There's power in the vote, but there's power in the dollar too. And from an economics perspective, there are ways to solve the problem going forward when you have these temporary issues. And that's just an important and key issue. When you don't look at the economics of who needs the water to survive, like a city, and the impacts of the economy during a drought, then you're really not doing your job, because there has to be consideration for the most, basic element of our lives, which is water that we drink and that creates the quality of life that we all enjoy here in Texas. So I would suggest that, between the water bank and a few other tools that we have out there, if we really started modeling droughts and looking at the calls that might occur and the difficulty in keeping the industry running and the jobs going, and go right down the chain from there, you'd probably come up with some answers of being able to be prepared better for a drought so that the system could go into place and the movement of the money could happen. Folks do maintain vast reserves for their municipalities, for river authorities, for others, for emergencies. And when we do it for the purpose that we might hit some kind of a crisis in which there's an interruption in cash flow. An interruption in water flow is the same to me as an interruption from cash flow. So I'd suggest that might be the way to start doing it, is pull together stakeholders and in the different river systems and start looking at what the likelihoods going forward with the changes in our climatic conditions are that we continue to want to predict. I don't think we can predict them. I was going to comment one last thing on the prior call a minute ago, which was, y'all were trying to do all this in real time. You didn't know if it was going to rain or not. Mm-hmm. I mean, right. And you didn't know where it was going to rain, for that matter.
We were doing some dances
and that's right. I bet you were. So all of that comes into play when we're doing these things, but right now it'd be wonderful to think of that and dream of that, but I just think it's too heavy a lift because we don't have that crisis in front of us. If we truly were out of water, that'd be the case. Having the knowledge I have of the groundwater that exists in this state, I'd suggest that it's likely that we'd start mining a lot of groundwater really fast if we hit a 20-year drought. There's a lot of water that's not being used that doesn't appear in your availability, primarily because it hadn't been developed. And there's also salt water in the ocean that could be brought up with pipelines. And I think we saw in the drought of the 50s, people would take a lot of resources and build pipelines and pumps and move water a long distance if they had to. A lot of that could happen before it might even change the law. You could do some temporary suspension under emergency, under the emergency powers and all that, but the rest of it, I think, is only if we hit that real crisis.
And I think, building on that, Kevin, it would again require, for that process of being able to move water quickly, using the power of the dollar to do it instead, I still think the legislature would have to get involved to build that seamless process. The challenge is for us, if we were to sit down and do that, I think every state agency would tell you we just don't have the resources or the time to sit down and try to do that. Now, if the legislature told us to do it and gave us money to do it, we'd be more than happy to. But trying to do that on top of everything else is challenging, or would be challenging.
One thing to think about though is it's a real problem, how to respond in the drought. But the priority system is, but it's not always as bad as you think about it, because we'll be talking about river authorities in a while, but like the priority call that Dow made in the Brazos River Authority has 11 different reservoirs in the basin and a lot of stored water that it supplies to its customers. And once the water is stored and you're releasing it rather than impounding it, it's not subject to the priority system. So the answer, to protecting your water supply during the drought is, part of it is not relying on run-of-the-river water, because that's not going to be there for everybody. But stored water, is going to be available as long as, the drought doesn't get worse than the worst drought we've seen before. Okay. All right, so let's talk for a second about what you have to do to get a water right under the current statutory procedures. There are several criteria that have been around, since about turn of the century, 1900. One is there has to be unappropriated water available. That means it's water that's not already permitted to somebody else, that's available when all of the water rights in the basin are using all of the water that's permitted to them. There's still some left over, and that leftover is the unappropriated part. And by and large, Texas rivers are pretty fully appropriated. There are times of flood and other times when there's a lot of water, more than is permitted. So there are times when there's water available, but during normal flow conditions and low flow conditions in most of the Texas rivers, there's not. Like Kevin was saying, TCEQ has the water availability model, the WHAM, that looks at the unavailability or the availability of unappropriated water when an application comes in. In terms of how much unappropriated water has to be available for a permit, TCEQ has a water availability rule that says, essentially, if it's a municipal use and it's your sole source of supply, it's got to be available 100% of the time, or they're not going to give you a permit for it. If you're an irrigator, they'll give you a permit if 75% of the water you apply for is available 75% of the time. So it depends on that, but the availability is the key to getting a permit, or one of the keys. And there is an exception that within this rule that you can work with, which is If you have another source of supply and you're not depending on the appropriation you're seeking completely, then TCEQ can just look at it on a practical basis. Is this going to make the water available reliably and, you know, avoid waste of water? So if you have, for example, a groundwater source in addition to the surface water you're seeking, you don't have to satisfy that availability standard. Or if you have multiple different water rights, you don't have to satisfy that. So that's one. Another requirement to get a permit is showing that you intend to put the water to beneficial use. Kevin, we had a series of interesting cases a while back on beneficial use. You want to talk about those?
I'm hoping we'll move a little faster than this.
Okay.
So that might bog us down if we start going over those real
Okay.
quick. So I'm going to pass on that.
Okay. It's a fun case, but we'll talk about that some other time. Another requirement is you can't impair existing rights. You can't get a water right that will take water away from the existing rights that are senior to you. And the permit can't be contrary to the public welfare. Those are the traditional long-time requirements. Todd, you want to go to the next slide? There's some more. More recently, drought contingency plans and conservation plans have been a requirement to get a permit. On environmental flows, there has been a lot of movement in the last 5 to 10 years. The legislature set up a process by which first scientists and technical experts got together and figured out ideally what the environmental needs of the river and the bay and estuary systems were. Those technical committees came up with a proposed standard, which they then gave to a stakeholder group that included some of the technical people, or some people with technical background, some environmental people, some water suppliers, all different ones. And that group, the stakeholder group, would modify the recommendation based on what they thought were the more practical considerations than purely scientific. The stakeholder group's recommendation then went to TCEQ, and the staff reviewed it, made a recommendation, and the commission then would adopt environmental flow standards for the river. And those then were the standards that you were legally required to meet to get a permit. So what used to be one of the key issues in a contested case for a water rights permit, you know, what should the environmental flows be, is now resolved. There's a rule that says what the environmental flows are, and things are much more efficient in terms of the hearing.
Yeah, and I'll jump in on that. Just 'cause from my perspective, I make the ultimate decision on what those environmental flow standards should be, and my view of the way it was set up is good. It brings everyone to the table. The challenge is that you have the be best, which is the scientific review, the technical analysis, and in some ways the scientific review and technical analysis would view the river as not having any human impacts, and sort of saying, what would it look like if people weren't using this? And so in some ways it's a little disconnected from reality. And then you get an advisory, you know, the stakeholder advisory committee known as the BBASC, which then takes a look at it. But by the time it gets to me, I have to make a decision that actually balances that environmental assessment versus human needs assessment. And so it puts us in a really interesting position because we don't always line up with where the original science was. And it's not because the science is bad, it's because we really have to balance the human use component of that when we make that ultimate decision. The interesting thing about these environmental flows is that it really has a process for adaptive management. So if new science, new info comes up, then then I guess through 2021 or so, we still have the ability to go back and revisit some of those if we have to.
Right, and although a lot of people think that every piece of legislation essentially is the same as, has the same components as sausage, and that's the same way it's made, that's not exactly what happened when this was put together. You had a lot of very key people from every kind of group you can imagine. Industry, the environment, environmental offenses involved Sierra Club, some of the people in this room, some of the people who would speak. And it took 2 tries for the legislature to get this thing done. It was not without an awful lot of negotiations before that finally came to fruition. And in the meanwhile, at the Water Development Board, the TCEQ, and at the Parks and Wildlife Department, we were being gathered by our chairman with our general counsels and executive directors to pull together a group of top-notch people to work our way through what we would do in stream, and we subjected it to review by the National Academy of Sciences. And I had the pleasure of doing a review of that document and had to provide comments on it, which is very unusual. The end result was a very, very carefully laid out process of collecting biology, doing the biology, doing the science, to come up with what we really did know about bays and rivers. And at the end, you have to envision that this is not just one. This goes across the entire coastline of the state and starts with the bays and works its way up those river systems. And some rivers are in the same group of bay basin, area stakeholder committees. I'm on one for the Trinity Bay and Galveston Bay system. And then you've got the Sabine, you just keep on going down the rivers, and you've got one for each one. I guess technically there's no bay for the Brazos, but y'all still have to have one. So, but in the end, we're going to redo these. They thought originally the first ones would be redone 5 years later, and it looks like it may be 10, I guess, before you do the first ones. And it wasn't perfect because we don't have all the science we need. Let's just be honest. So we had to make an assumption, and the assumption was that that the river systems and the bays themselves are not too bad right now. They're in fairly good shape. So how do we maintain them? And so we're trying to come up with water budgets, both for the bay as well as different segments of the river. And we've started with priority sections of the river, and there was a budget set out for that years ago under SB2. And in SB2, which is the one I was referring to as far as the in-stream flow goes, that actually is taking a long time. And we've just now are finishing some of the work that we started years and years ago, because we don't have perfect weather in Texas. And you have to have good, weather cycles throughout entire years sometimes for us to get data sets that we need. So I just want you to know, it's really, this is a collaborative effort. We have the waders and wading boots on the ground in the Trinity River for the Trinity River Authority, with Parks and Wildlife staff, with Water Development Board staff, and others. And then we have consultants that we pay as well, and professional firms and scientists and modelers and mathematicians and you name it, to do all kinds of work on this. And the state and the community that works with water has taken this very seriously, and we believe in it. And despite what was said back when I first started in this with, you're not going to like the answer, and so you really don't want to do this, we want the answer. Can y'all hear me? Sorry about that.
And then the other thing I would say is, you lay on top of all that some would say that the WAM needs to be reworked, the model itself, and there's been some the legislature's tried to do that, but at some point I think we will get the money to do it. And I guess the point being that with the WAM, it's a great model, it works, but we don't know exactly how much water we actually have available until we really update those and use the best available science that we have now to do that.
Yeah, there are many areas of the state in the last round of drought that experienced a worse drought than they've ever experienced before. So that ought to be those ought to be the critical years in the WHAM to determine what the lowest amount of water available is. But the WHAM cuts off about, 97? and doesn't have years since then in it. So it needs to be updated to include the more recent drought, and that'll make a difference in some basins. Couple other requirements to get a permit. The project has to be consistent with the state water plan, so that the permitting of TCEQ is kind of in sync with the planning that the Water Development Board is doing. Also, there's a requirement that you consider the impacts of the proposed appropriation on groundwater, which that was added a couple of years ago, and it's interesting that surface water appropriations consider their impact on groundwater, even though the groundwater is able to be taken and used without considering the impact on surface water by and large. And then there's the requirement that interbasin transfers receive special authorization, and the junior rights provision that you heard about yesterday, saying that if it is authorized, it becomes the most junior right in the basin, which, given the prior appropriation system, makes it worth not very much.
So with that, we're going to kind of speed up a little bit here, but I would like to get a gauge from the three of you on what you think the impact of that provision has been.
The interbasin junior rights provision?
Right.
Well, I think it's kept it from happening. We see bills filed almost every session to address that, and eventually one will pass, I think. We're just not there yet.
Depends on what you call the junior rights provision. I mean, there's one specific requirement in there that says junior and about transfers and agreements between reservoir owners and river authorities and all. But the rest of it it's a lot of provisions that protect the basin of origin. So the answer, I guess, is that it's maybe not timely for it to change, but at the same time, it would help move water if you could change it. And I think since it's been in place, there's no incentive for us to go get it until it becomes like the only way we can go get the additional source water. And unless we are really convinced that there's not going to be another existing water right that's going to impact us in that basin of origin going forward. Now, if you build a reservoir in that other basin, it changes it quite a bit. So it has little or no impact in some cases as well. And we've been talking about all the water being appropriated. That's true of all the water that's been developed in the state of Texas, but there is still quite a bit of water in the river systems that flows out of the state that could be captured and conserved in some rivers in the state. But then, challenge there is can you get it done? As you alluded to a minute ago about a certain East Texas river system and lake.
Yeah, there's a lot of water in East Texas, and it could be used. It could be going to the Houston, Dallas metroplexes and be used there, and it would be cheaper probably to put in the transportation system to do that than to develop new reservoirs and new sources that are much less abundant.
So on this one, what I'd like to ask, is this the way that we could maybe get at a market system for surface water in terms of the ability to amend existing surface water rights?
I think it's a step in that direction, absolutely. And what this provision says is the commission shall grant an amendment if that amendment doesn't increase the appropriation authorized, and if it doesn't have any greater impact on existing water rights and environmental flows than full exercise of the unamended right. There's a kicker that it also has to satisfy other applicable requirements, which has led to some litigation and adds a little uncertainty. But without that uncertainty, this is a good first step toward setting up a market system. And in fact, we just finished a hearing on an amendment application by LCRA to amend the Garwood water right, the most senior one in the Colorado River Basin, to allow use at all of LCRA's diversion points on the river instead of only the diversion point that was authorized. And what TCEQ staff did, and it looks like it's going to stick, is using the WHAM, they made a proportion of the naturalized flows at each of the diversion points. So that if up at Austin, it had half of the naturalized flow available that was at the Garwood diversion point, then half of that water could be diverted under the same priority up at the Austin diversion point. And if something like that were institutionalized as a rule, that would make amending water rights to change the point of use, which is a big deal, relatively routine. I think there's hope here.
And that is an ongoing challenge when you change diversion points. It changes, where the water is in the river and where it's coming out. And so that is a tougher tougher analysis to perform. But the challenge is, if you're going to get to the idea of a market, we do have to build a system that allows the amendment of water rights fairly quickly, because as we talked about earlier, your right is sort of linked to whatever a specific use. And so if you're then going to contract and sell that water to a city, if you're a farmer and you don't have that in your right, we have to go in and amend it to do that. And so not everybody has that ability. So being able to build that into the system would absolutely at least make the transfer of that water more efficient.
So surface water law institutions, federal institutions, most of the population centers of the state not really dealing with the IBWC or compacts, but the Corps of Engineers and the Fish and Wildlife Service in particular, that's a different thing. And the relationship is very different here in Texas than it is in other states with these federal institutions. You go out west, it's all about the Bureau of Reclamation and what Reclamation wants to do. The relationship is fundamentally different though here. And just wondered if you might want to comment on that.
We do have Bureau of Rec facilities in the state, and we have Corps of Engineers facilities in the state, and there is jurisdiction from both. And then of course U.S. Fish and Wildlife is a part of every permitting process. They're not as evident sometimes, but they really are there. And EPA is got the veto power on anything. We're right now as some state organizations that we have trying to get some reform in the way that they apply the permitting requirements that people refer to as NEPA, but I don't think that's quite accurate, because there's a couple of other things that get looked at when you have a project that's not a federal project, it's not supported by the feds, that are much more stringent than what you have that apply to a federal project, and little discretion is given to the feds in those analyses. So those probably are the biggest threats right now. And then there's been a lot of rulemaking that occurred that came from several years ago that we are watching very carefully, and we still haven't been able to head off. Some designed to solve problems in other states, water system problems that would be a big threat to things like reuse in the water in the state of Texas that the Corps of Engineers has, which is known as the Water Supply Rule. And then we have the Waters of the U.S., which I know what they try to put out there publicly of what it'll do, but that's not what it says. That one's, under suit currently. And then we have something that is called the planning and basically planning requirements, and then the guidance, PR principles and guidance is what we call it. So, but it's planning principles and the guidance, and that is. Actually, they subjected that to a review by the NRC of the NAS. National Review. Okay, I'm sorry, but that's the arm of the National Academy of Sciences that looks at these types of things, similar to what we did within the in-stream flows. And they actually told the Corps and CEQ, because CEQ wrote them. Council of Environmental Quality works under the Office of the President. That those, they couldn't deploy them because they hadn't really talked about how they would be put into place in all of the various agencies that it applied to, because you took what normally would have just applied to a planning process under the Corps of Engineers and applied across the boards. This could affect everything we do in the future. So we can't forget about these things. And on the IBWC, I've been involved with them before when I was at the Water Board, as well as the River Compacts. I'd say the River Compacts do a darn good job with Texas and our adjacent states, and always have. And generally their employees work out of the TCEQ, and they really have. They coordinate quite well. And I don't, we've had a few problems with the Red River, but other than that, really, I don't think we've got anything serious. IBWC, it doesn't help us a bit with our border conflict on the water from Mexico that they don't give to us unless it floods. So really, these, I think we could almost pass on these because we're active in them, but there's nothing really we can say that we can do other than provide comments and hope that they change.
And I'll throw in there, for the Rio Grande IBWC, we really are beholden to them and sort of working out those water debts with Mexico. The way the treaty works, each country is allocated a certain amount of water. Mexico's supposed to give us a certain amount of water. They typically don't until it floods, like Kevin said. But the challenge is that we have it's the International Boundary and Water Commission that really oversees that whole process. So while we work with them, they're the ones who are trying to pull the levers to make that work. On the compact, obviously, also regarding the Rio Grande, that's where the lawsuit is right now. And basically, the basic premise of that is that we're not getting the water delivered that should be delivered to the state, and that's what's being that's what's in front of the Supreme Court right now. So that's another issue that's ongoing. And obviously, yes, Waters of the U.S., I'll hit on that. Waters of the U.S. on its own, if you were to just read it, you'd be concerned. But what I get really concerned about with Waters of the U.S., because I've seen it with every federal rule that's come out, as soon as it comes out, an activist group, somebody comes in and sues, and where you think the rule started out here, and now the rule's this wide, and then there's another lawsuit, and now it's this wide. And so that's the if I were to look at that rule, my concern is it's going to start here, but by the time it goes through the different courts, we thought it was going to do this, and now it does this, and so that's the challenge that I see with that rule in particular.
So, river authorities. Now we've got 18, I think, and 18 or so. There are organizations that are essentially like river authorities, but not called that. BRA was created in 1929, and I guess my question I want to ask you, Kevin, is, has the model evolved over time? Does it need tweaking? If there were additional authorities, abilities that were on the table, what would you say might be necessary to make river authorities, I guess, capable of getting us through the next 50 years?
Well, one simple thing would be to at least give the district management the same kind of authority that a city manager has when it comes to contracts. This is just administrative, but my maximum change order I can do on a contract, and I have over $300 million worth of contracts underway right now, is $50,000, and a city manager can do $250,000. So I have to take over all the ones over $50,000 to my board. Now we'd make it work, and we've got a way to do that. But it is rather insufficient, inefficient in the long run in today's contracts how large they are. But for the overall, they've given us such broad and sweeping authority in most cases that really it's hard to say they could do much more. Having said that, what we're watching, and we want to carefully work with the folks that are starting to consider this, is are they going to give us additional responsibilities with regard to flood? and with regard to flood mitigation. Because there seems to be an assumption that if you're the river authority and you have jurisdiction over the entire basin, then you obviously have the biggest footprint and the ability to handle that. So if that does happen, we will be very interested in what that does and how that works. We have some specific legislation that affects the Trinity Basin that requires us to do some coordination on flood. Not all districts are that way. I'd also say that there is inconsistencies. Every river authority was created by an act. I mean, and so we're all different. At the time when we were created, there was some necessity. And so ours leans more towards regionalization of wastewater and providing services of water treatment and all that. And at one point, navigation of the Trinity River. And you know, others don't really quite speak to some of those things. And you'd have to do a very careful analysis of each one to see where those inconsistencies lie and see whether or not you wanted to add some that some others had that might be beneficial and make those a little bit more consistent across the board. And then we all, when we get together to do things, might find a way to learn from one another.
So, Watermasters. I was thinking during Charles Porter's presentation at lunch yesterday that the water tender on the Acequia in Bexar County was maybe the first Watermaster. And we've had Watermaster in the Guadalupe and San Antonio River basins. I guess that's maybe the first, or at least they've been there for a long time. Now starting to, appear in other river basins. Just your thoughts. I always kind of wondered, having been in a system where there was a Watermaster, I always wondered why everybody didn't have one. I mean, sorry.
Well, I'll tell you, I'll address this quickly. The challenge with the Watermaster is that it goes to the fact that it costs money, and the water right holders actually pay for those programs. And as the Brazos is finding out, they now have to pay for it, and that's a long stretch of river that has to be managed. And the essential idea of a Watermaster is that the best way to describe it, you almost have an Excel spreadsheet that says, here's how much water is where, and here's who the priority right holders are. And as water goes down, you're tracking all of that and making sure that people are getting water as they need it, based on the flows in the river and priority doctrine. On the Rio Grande, it's a little different in that there's two buckets, Amistad and Falcon Reservoir, where the water is sort of stored, and then as it's needed, it's sent down the river to where those needs are. So right now we have one, the South Texas, Brazos and Concho Watermasters, and then the Rio Grande, and they can be created through the legislature, can tell us to create them. The commission on its own can create them. Our water staff, if you have in-depth questions about how this happens, they're sitting right over here. But they do reviews on the river basins in the state, and then make recommendations to the commission on whether we should create Watermasters. And then the other way is that the water right holders can actually petition us to create a Watermaster. That's what happened on the Brazos River. But what you're essentially doing is creating a new system that's supported by taxes, and so while the water right holders may want that and petition for that, I'm never gonna go advocate that I would put a new tax on water right holders to manage their own water, and so that's the challenge. And when you get into these longer river basins that have a lot of old rights that are very complex, the cost of actually managing that Watermaster system is more than what I think people realize when they come in and ask us to do it.
I think it's kind of like the legislature that, people are not going to want to pay for a Watermaster to regulate their activities until there's a drought and something that really gets them to it. And I wanted to mention the Rio Grande because that is the exception to the prior appropriation rule in Texas. They do not operate on a priority system. they have a priority of use type system so that the municipal and industrial rights get the water preferentially. And all the other irrigation rights, which is most of it, are on a level playing field. And they have a very active, effective water market in the Rio Grande that's overseen by the Watermaster.
So I received a notification from the TCQ the other day that once again, every so often, every so many years, they consider whether they'll do a Watermaster or not. And so the letter's in the mail.
So we're kind of running out of time here, and we've talked about some of these items. We didn't talk about freshwater mussels, and everybody's going to be talking about those, I think, in the next 5-10 years. Just, hey, that's my prediction, having been through a lot of endangered species work in the next session, possibly. So return flows. I know y'all had some thoughts on that subject. Let's hear them.
The return flows are a bit different than other water, and because sometimes it's not really clear as to who might own those return flows or who should be entitled to file a permit, and that's something that has to be sorted out from time to time. Some of the entities may have a law, some may have just contract that says that, you know, we have the full, you know, initial permit to appropriate, you know, for appropriated water and a water right on this, and when we supply it to you, we still own it until it returns to the river, whatever's left of it. And those folks might apply for a reuse permit. Someone like me might say through contract that once I've treated it and I return it to the river, then I have a right to ask for a permit on it. It belongs to the state once it hit the river. I mean, so it's the water of the state, it's clear. But you then go apply for a permit. And I just would encourage folks to consider that these are probably some of the most difficult ones to put together and model and work with. And they require an accounting system that depends upon, you know, metering and discharges and wastewater permits and points of entry and points of diversion. So we talked about the constraints of the commission, particularly like when we get a drought and we get a prior call. I think it's very helpful on these river systems for the people to come together in advance of doing these things when they put their permit together and work out as many issues as they possibly can to avoid an extended contested case hearing on these matters, so that we can actually put these flows to work as soon as we can and get at least the elements of the water plan related to water return flows in a position to be contracted, because until it's permitted, you're not going to contract it. I mean, I say that, yeah, we might, based on speculation of what we'll permit, but until it's permitted, that contract's not perfected anyway. So that would be my perspective from a river authority that actually does this and has return flow permits. Years ago in the Trinity, and around the 2000 or so, a lot of folks applied for permits virtually at the same time from the upper basin in order to get all of that water secured. And it resulted in many years of hearings and negotiations and, you know, agreements that now are a part of many of those permits, and that when we recently amended ours are still a part of it. We had to work through those issues. It is different than just normal surface water.
Anybody want to add anything else about return flows?
I'd just say that the statutes and the case law on use of return flows are, you know, you don't want to say they're contradictory, but they're awfully difficult to make consistent and to see a clear path for how to use these. And it's a great area for lawyers. But the return flows, it's hard to overstate the importance of return flows as a source of water, because they're growing, and they're the only source of surface water where the supply is really growing. And they're reliable. They're there during a drought. The sewage treatment plants discharge that water all the time. So it's a critical issue to get right, and you know, we're edging our way toward that, I think.
Yeah, the only thing I would say, you know, for people who don't know, most water in our rivers are return flows that are coming from wastewater treatment plants. So the stuff that you're drinking downstream is stuff that, for all intents and purposes, got flushed through a toilet upstream. So so that's really where when you get to the end of a river basin, all that water at some point has probably been a return flow in some form or fashion. What this is really talking about are those communities. So direct reuse would be that community just taking the water straight from their wastewater treatment plant and then putting it back into their own system, and it never goes back into the river. And then the indirect reuse is the water actually goes into the river before it's reused. And so those are kind of the two different paths forward there. The interesting thing there is that I think, and I don't know if anybody's really looked at this, but as the cities need more and more water, I think we'll see, my guess is more and more direct reuse. And my question with that is, and I don't think we know this yet, is how does that impact the flow that typically goes into the river and downstream as cities start to realize that they can do this. So that's I think that if I were to look at a challenge going forward, that particular issue is something I'm concerned about.
So I'm going to go ahead and summarize these other issues so we can get to some questions. So, 75% population increase by 2070. The available supplies we have now are decreasing. We're going to need 9 million acre feet by 2070. And surface water is, pretty well appropriated right now. If you look at the state water plan, $63 billion over 50 years to implement that plan. But infrastructure, another 120 to 160 billion on top of that to maintain and improve. So it's a big bill that someone's going to have to be paying.
Doesn't Trump have an infrastructure plan?
We're all going to be saved, it sounds like. But we have new technologies. That's maybe one reason why we don't have as much reservoir construction. There's some alternative water supply technologies available, storing groundwater and surface water underground, desalinating brackish groundwater and seawater, conjunctive use of surface and groundwater, and maybe water marketing.